Hi, this is Mike Young, estate planning and elder law attorney in Walnut Creek, California. And I'm going to talk to you about procrastination and estate planning. But before I do that, do me a favor and hit the subscribe button below and the like button. And you can also leave a comment for me, and you can leave a question, and I'll try to get back to you on the question. Also, just to let you know that I put on interactive Zoom workshops on the second and fourth Thursdays of every month at 10 a.m. And the workshops are fun and interactive and informative, at least I think they are. So go to my website, walnutcreekelderlaw.com, and sign up for one of my workshops. So people seem to put off creating their estate plans absolutely forever, and there's different reasons for it, I have discovered. I have to tell you that the oldest client I had was a woman, 99 years old, who waited until that time to create her estate plan. Fortunately, she had all of her cognitive abilities. I involved the family, and we created a wonderful estate plan for her, and she passed away well into her 100th year. But don't do that. Don't plan to do that. So I guess one of the reasons people put off their estate planning is that there's nothing pushing them to do it. There's no big deadline like there is when you need to file your federal and state income tax returns every year. Another thing is that decisions weigh heavily on people's minds. You know, how do I want my money to go when I pass away? Do I want this son to get the same amount as my daughter? There are good reasons for this, they'll tell themselves, but I can't make that decision. They can't decide who their fiduciaries are going to be. Who is going to help them if they become ill on their health care powers of attorney. If they don't die and they become ill, how do they want things to be handled? How are they going to be taken care of? Who's going to help do that? A lot of times people are afraid to call their attorney. I understand that a lot of attorneys will send out a big form to these potential clients, or to you, for instance, and I've seen forms that are 10 and 12 pages long, highly detailed, where the clients are supposed to answer all of these questions, go through all of these thought processes on their own before they even go see the attorney. So that's a big barrier. Maybe they think the attorney is too expensive, but I think my clients know that the expense really isn't that high, and the expense could be much higher if you don't do something and you pass away, or if you become ill and you need help. So some of the things that motivate people to give their estate planning attorney a call is maybe a health scare, maybe they've broken a hip and they have to go to the hospital and are then discharged to a skilled nursing facility, then discharged from there, and then it will hit my clients, how will I pay for a skilled nursing facility if I need to stay? And they know that they need to get their ducks in a row in their estate planning, both for when you die and if you don't die and you become ill along the way. And California has a wonderful program, as you may know, called Medi-Cal, which can help pay for a stay in a skilled nursing facility. And we can utilize our estate planning. We do utilize our estate planning documents to help get our ducks in a row for asset protection and to help pay for a stay in a skilled nursing facility and to keep assets in our estate for our spouse and ultimately for our family and our beneficiaries. Sometimes there's a diagnosis of a mild cognitive disorder a diagnosis of early Alzheimer's disease, early Parkinson's disease, that sort of thing. So the longer you wait with that sort of a diagnosis, the more difficult it is to create a good estate plan. So another thing is grandchildren coming along. Maybe you want to have trusts for grandchildren or specific bequests for grandchildren. For my younger clients who have young children, the biggest issue that weighs heavily on young clients, young married people's minds is who is going to take care of our children. If something happens to us, who are the guardians going to be for our children? I think I misspoke. It doesn't have to be married people that have children, but you know what I mean. It's a big issue. Who are the guardians going to be? So feel free to call the attorney. Feel free to give me a call and make it very easy for you. And the first thing I tell my clients is, well, the first thing they tell me is, Mr. Young, I feel so bad. We've put this off forever. And I'll tell them, don't worry about it. Everybody seems to put this off forever. But the point is, you have taken a step and you have given me a call so that we can at least start the dialogue and start talking about what we have to do. Sometimes my clients will call me and tell me this is a triggering event to give me a call. You know, an uncle or an aunt passed away, and that estate is a pure mess. People are going to get assets who shouldn't get assets. I know my uncle didn't want things to happen this way, so this can be a triggering event for people. So give me a call or give another estate planning attorney a call and start a dialogue. You can email to me, lawyoung1@gmail.com. You can watch my YouTube videos. Look at my website, walnutcreekelderlaw.com, and start motivating yourself by learning a little bit about estate planning. But I make it easy for my clients. And a lot of times when I meet with my clients, I'll map out what we're doing on a big whiteboard in the conference room. Because of the virus now, a lot of times we are meeting with clients. I am meeting with clients via Zoom and using a split screen with the same diagram. So I make it easy on you is what I'm trying to say. So go to my website, walnutcreekelderlaw.com, sign up for one of my workshops. You can send an email to me to lawyoung1@gmail.com, and you can give me a call, 925-256-0298. So I hope to see you either on Zoom or in person. So thank you for watching.